And I went to court down here in federal court on the Entergy case. We finally got an Entergy cornered after a decade, literally a decade, 10 years. This has been going on. I've been investigating and trying to get Entergy to pay Mississippi like they settled in Louisiana about 18 years ago. The lawyers in the Louisiana case brought the evidence over here, and I had the evidence before me. Most cases that I file, I don't have the evidence, but in the discovery process in the Louisiana case, they gave the lawyers the Mississippi purchases. And so now, just today, we're set for November 5th to go to trial with Entergy after a decade of battling. They owe the ratepayers in the state of Mississippi probably well over $1 billion. If you add in interest and possible penalties under the Consumer Protection Act, it's well in excess of $1 billion. So it'll probably take 2 weeks of a trial down there, but it's time for Entergy to step up and give the money back that they've wrongfully taken from the ratepayers in this area. So we're encouraged by that. The judge has indicated that if it takes the month of November, we'll be down there in trial. So we're looking forward to that. In fact, I agreed this morning to just waive a jury trial. Just let the judge make that decision, because that would be another issue. They can drive it, try to go down to the Fifth Circuit and appeal it. I've been to the Fifth Circuit, I know, 3 times already on this case in this past decade. So it's time for them, when you see a company that just it tries to dodge and put off and hope that we will go away, you can bet they're guilty. If they weren't, they'd just tee it up and go to trial. And so this is one of those that we've got them cornered, and they're going to have to pay one way or another soon.
Specifically, what is that issue?
Well, with Entergy, what they did is, when you get a monopoly, you enter into a compact with the state, and that says you've got open book. You've got to open your books, and you're entitled to a reasonable profit, and you have a duty to sell the lowest priced electricity available. And so there was these small, more efficient gas-fired generators around the state. There's one up near Kosciuszko on that pipeline. There's a couple of them actually, and they were much more efficient than the old 1950s model generation plants that Entergy owned. So what they did was they would buy that cheap electricity generated by these little independents out there, and then they would sell it on the open market like Enron did. Remember, Enron was trading in electrical trading, and so they put that in the pocket of the New Orleans parent company, and they sold us the old expensive stuff, our ratepayers. So that was in violation of their duty to sell at the lowest price. And they manipulated their transmission system, because they had their own separate transmission system, to try to choke off those little plants. And so I got a hold of I think it was about a 60-page PowerPoint presentation by the Entergy CEO at the time, J. Wayne Leonard. And he's talking to a group of stock analysts, and he's talking about shooting down the competition. He's talking about antitrust violations. You flip a page, and it was another bullet in the revolver, and they were talking about like the little plants that they ended up buying. They would choke them down, they wouldn't buy enough electricity from them, and then they would buy them at scrap value, these little plants. And then the next thing they would do, they would turn the generation up to 100%, whereas before they might be buying 10% from them. So I took that to that same room I was in yesterday. I thought about it sitting there with the Attorney General and all the others. Is in that room is where I put that on the table and showed it to the Department of Justice Antitrust Division, and that's when they made Entergy have divide out their transmission system, made it part of MISO, is an independent organization, so they couldn't manipulate the purchases of electricity. So they settled that case pretty much on the same facts over in Louisiana. They paid over $100 million. And I assumed that when we filed our suit back in 2008, I filed it in December of 2008, but we actually had litigation well before that. If y'all remember, we set a civil investigator demand, and we were in state court, and they they ran to court and tried to block that. So there were battles even before we filed this suit that we're moving forward on, now, and that we argued about in court today. So hopefully, you know, they'll come forward and offer some settlement, but I don't anticipate it. They got a fleet of lawyers. They got plenty of money. J. Wayne Leonard, that guy that was the CEO at the time that they got caught with this antitrust violation, he bailed out with a golden parachute. I think he had 11 million or something to that effect in a golden parachute, and all he wanted to do is put it off and not, you know, see that kind of payment come out on his watch. And that's what a lot of corporate leaders do now. They're not entrepreneurs that begin businesses and want the reputation of that business to continue to be solid. They're just trying to, you know, get their stock options and bail out with a golden parachute. And that's what we're seeing, unfortunately, with a lot of American corporations that are, you know, doing things they shouldn't be doing.
Who's the judge?
Judge Carlton Reed.
And were you there?
Yeah, I went up there and argued this morning. Remember, it was before Judge Wingate, and it went all through all those gyrations, and